Today on Law Weekly, we discuss some of the recommendations of the Committee on Law, Judiciary, Human Rights and Legal Reforms of the National Conference. That committee is headed by Retired Justice Adesola Oguntade. And last week, its report was one of those that came up for discussions at the conference. Joining us to look at some of the recommendations is Senior Advocate of Nigeria, Chief Robert Clark. Chief Clark has always had some interesting comments on the workability or not of some of those suggestions. But we'll get to that discussions in a bit. Let's first do a recap of some of the top stories from the court. The program is Law Weekly on Channels Television, and I am Shola Shuyeli.
We begin with a report that the Supreme Court last week Friday dismissed a suit by 16 northern states through which they had sought an order compelling the federal government to pay them about 7.039 billion naira as compensation for some assets of the northern region taken over in 1977. The 16 northern states had sued the federal government through the Attorney General of the Federation, alleging that the federal military government forcefully took over the assets owned by the defunct Northern States Marketing Board, using Decree number 29 of 1977. The court, in a unanimous judgment, held that the Northern States delayed in filing the suit, and as such had been caught by expiration of time. The Apex Court held that the plaintiffs ought to have filed the court action immediately after the federal government admitted its indebtedness to them through a letter dated July 27, 1983. From the Apex Court, we move to the Federal High Court in Abuja, which last week Wednesday ordered the Inspector General of Police, Mr. Mohammed Abubakar, to jettison any directive by the National Assembly that the Minister of Petroleum, Mrs. Diziani Alison Madueke, should be arrested for her alleged involvement in the 10 billion naira jet scandal probe. Some officials of the ministry and the Nigerian National Petroleum Corporation are also protected by the court order. Justice Gabriel Kolawole made the order during ruling on an application by Mrs. Alison Madueke's lawyer, Chief Mike Ozehome, who had sought the order in view of the threat by the House of Representatives to order the arrest of the minister and other officials. The order is to subsist till July the 3rd, when the court will hear a separate suit filed by Mrs. Alison Madueke along with her ministry and the Nigerian National Petroleum Corporation. The same court last week also granted an ex parte application filed by the People's Democratic Party for substituted service against its 5 governors who defected to the All Progressives Congress. The PDP had sued the governors, praying the court to declare their seats vacant on account of their defection on November the 26th, 2013. The affected governors are Abdul Fattah Ahmed, Chibuke Amechi of Rivers State, Rabiu Kwankwaso of Kano State, Aliyu Wamako of Sokoto State, and Muritala Inyako of Adamawa State. Justice Gabriel Kolawole, by the ex parte application, says the PDP shall, within 7 days, publish one insertion of the suit in a newspaper. The defected governors would be entitled to 30 days within which to respond. And we'll round off with a report that 10 people who were involved in the torture of 3 women in the Ejigbo area of Lagos were last week Friday arraigned before a chief magistrate court sitting in the Igbo area of Lagos Island. They were arraigned on an 11-count charge bordering on conspiracy, attempted murder, threat to kill, unlawful society, neglect, torture, and assault preferred against them by the police. The police prosecutor, Charles Odi, told the court that the defendants and others still at large on or about the 11th of February 2013 conspired to commit the alleged offences which took place at the Oba Morufu International Market in Ejigbo, a suburb of Lagos State. The defendants were also said to have attempted to unlawfully kill one Juliana Agomma by inserting a stick into her vagina, which almost caused her death. They also assaulted one Ajoke Agomma and another Nike Salami. All the defendants pleaded not guilty to all the charges. The court granted them bail in the sum of 100,000 naira each, with 2 sureties in like sum. The matter was adjourned to July the 23rd.
Now, if you missed the highlights from the report of the Conference Committee on Law, Judiciary, Human Rights and Legal Reforms, Channels Television's Lanre Lasisi has details in this next report.
The day commenced with the consideration of the report of the Committee on Law, Judiciary and Legal Reforms. After the chairman gave a summary, delegates discussed the report.
The referendum should be adopted so that the people will have the right to pass judgment on the proceedings. If by 51% the electorate adopt a resolution, my humble submission that the new constitution will have come. The present constitution is a military dictate. The Abdul constitution has expired. We need a new constitution for Nigeria.
Before Nigerians, to say that this constitution has expired, or for somebody to stand here and tell us, and tell Nigerians and the world, that this constitution is illegitimate, I think this kind of statement is impinging on the credibility and integrity of members of this conference.
And even though about 300 delegates sought to speak on the committee report, the conference took views from only 80 delegates before moving on to consider the amendments.
All those in favor of the establishment of constitutional courts, say aye. Aye. Against, say nay. Nay. The ayes have it. All those in favor of anti-corruption courts, a special court, say aye. Aye. All those against, say nay. Nay. The ayes have it. A clause of the right to self-determination should be added in the Nigerian Constitution. All those in favor of that say aye. Aye. All those against say nay. Nay. The nays have it. Finished.
The conference also rejected the recommendation to have prison services moved from the exclusive legislative list to the concurrent list. The report was adopted at the end of the day. Lanre Lasisi, Channels Television News.
Flowing from that report, I sat down with Chief Robert Clark, SAN, last week to discuss some of the recommendations and what he thinks of their sustainability. Chief Clark has practiced law in Nigeria for over 30 years and is one of the most respected lawyers in the country today.
There is no reason why we should have a special court for corruption. If we have a special court for corruption, how do we define corruption? And how do we design which cases will specifically go to that court? I think within the system that we now, undertake, there is no reason why we should find a special court for corruption. Corruption, it's part of the criminal actions which any criminal court in the state judiciary can handle.
Even if we have the chief judges make practice directions for what cases will qualify as corruption cases, it won't work.
It will be difficult. You see, the dichotomy of what constitutes corruption can be enlarged by anybody. You see, what I find to be corruption may not be corruption to you. It depends on circumstances. And when you start finding that there will be difficulty in ascertaining what constitutes corruption or not, it is better not to, go into the area of isolating it before sending it to a special court. What you'll find lawyers doing at that stage is to start raising jurisdictional, objection that, oh, this court has no jurisdiction because my client has not, committed any corrupt act. And then again, you have to determine what constitutes corruption. So corruption,
the whole new set of challenges.
It's going to start another system of challenges. So let us look at what we have and make good with it.
Another one is this abolition of the plea bargain system. Do you think that we should have an outright ban of the concept?
Free bargaining has never been part of our judicial system. Let us be honest about that. It has never been part of the Anglo system of governance also. But it has surreptitiously crept into our judicial system from 1999 when EFCC was brought into the show. Fortunately or unfortunately, under the new Lagos State 2011 criminal rules, plea bargain has been entrenched as part of the law of Lagos State. And let us look at it. There is nothing basically wrong in plea bargaining. Let us be honest. It is how we use it that can give rise to any suspicion. We have seen it being used in Nigeria. We have seen it being used in Lucky Benedict's case. We have seen it being used in Cecilia Ibru's case. Now even Cecilia Ibru is challenging that certain acts that have been included in her plea bargaining were not acts which part of the original. So there is nothing wrong in it. It is the operation and the way we do it. Because let's be honest, if it's going to take us 5 years to charge a public officer and get a conviction in Nigeria today, which we have not been able to do, virtually all the governors that have been charged for the past 10 years, since 2004, those who have left office, who have cases, one of them has been convicted.
Would that not be because, like some people say, there's no political will to try those cases?
Look, once cases are brought into court, the question of political will no longer, exists. So let's be clear about that. Once a governor is charged and he takes a plea in the court of law, politics is no more playing its role there. What is playing its role there is the dexterity of lawyers who are handling the cases, who can use every trick in the criminal procedure rules and in the court rules to elongate, the time of, So what I'm saying is that instead of going through, let's be honest, there are about 6 or 7 governors today who are facing criminal charges. It's not because of political will that they have not been convicted or discharged. It's because of the maneuvering of the court system by lawyers. So if there is court, plea bargaining, many of them will be ready to plea, to take a plea, and then, forget all the, but for those of them who still want to continue in politics, plea bargaining may not, be very, advantageous to them.
What's the solution, though, to the tactics of lawyers stalling cases in court?
Look, it is not the tactics of lawyers stalling cases. Let me first bring this. I am not against the prosecutorial method of EFCC, but let me be honest. Most of the prosecutors today of EFCC are not trained in prosecutorial matters. They don't have the lawyers within the system of EFCC to prosecute. They now hire lawyers outside, some of them senior advocates, who are not even trained to prosecute. I am sorry to say it, 90% of the senior advocates today that are prosecuting have no experience of prosecuting. And that is why you find 150 charges, 70 charges, 40 charges, when a real prosecutor will nail down with 5 charges and get a conviction. So you see, the problem is not that lawyers are using certain machinations.
But the EFCC is not hiring the right kind of lawyers.
No, but they are the available ones. You see, the DPP's work in any system of prosecution is very important. The Oyinbo man knows what they are doing. When they say there's a department known as DPP, they are trained. And these people are trained to prosecute. We have, in our younger days, people, who were well-known prosecutors. But today we don't have them again. They are only limited within the judicial system of the Justice Department. They are not available to EFCC. And EFCC has to go out to take practicing lawyers who have never been trained. Let me give you a clear example. I will not name a name. There is a prosecutor for EFCC today who is a noted human rights activist. This is a man who has gone to court to ask for bail for a man who has been charged for treason. The same man now prosecuting on behalf of EFCC will go to court and oppose bail in a case of stealing. And then you look at such a man. I called him one day. I said, look, how do you feel? In Abuja, you have just applied for bail for somebody who is being charged for treason. You have come to this same court with me. You are opposing bail for somebody who is being charged for stealing. How do you feel in your mind? That is the attitude I'm trying to show. That we are picking people who have not been trained to prosecute. So they make so many mistakes. They give room for so many mistakes. And we lawyers, we take advantage of it. And that is what we are trained of. We have to defend our clients to the best of our ability.